Welcome to the Melinda Eitzen Show. I'm Melinda. Today we have with us Liz Porter. Excellent lawyer, family lawyer, divorce lawyer. I know because I've seen her in action. Thanks for being here, Liz.
Thank you, Melinda. Glad to be here.
We're going to talk about unconscious coupling. What is unconscious coupling? What does that mean to you?
So I guess the term came about, I think, when Gwyneth Paltrow and Chris Martin divorced, and that I've heard that term resonate with several clients that have come in. We kind of, they've said, I want a conscious uncoupling divorce. And so, what I've thought about is, okay, what does that really mean? What are people saying they want?
Yeah.
And the way I think about it is they're wanting, to get through their process, through their divorce process as amicably and efficiently as possible. And I really believe that that's what they're looking to do.
I agree. I definitely have seen that in my practice also. Sometimes, even though they say that, hey, I want this to be amicable, sometimes they take actions that are sending a war cry, and they don't even know it.
Yeah.
So give some examples of that.
So I think the first example is when, the divorce first starts, serving the other party. I think that can be a very jarring experience. So what I try to encourage people is, think about the different options, when the divorce is going to be filed. Are you really wanting to have a process server knock on the door and serve your spouse? There are so many other options. And so, and so we talk about what those are, letting, after you have filed, letting your spouse know that I have filed for divorce. How would you like to receive the documents? They can be sent to you directly. They can be sent to a lawyer on your behalf. What is it that you want? It gives them the opportunity to kind of take control over that process. So that's one example.
No one wants to be surprised or embarrassed getting served at work.
Yeah.
Oh, gosh.
Yeah. Or in front of children. We see that.
Yes.
Yeah.
And sometimes people serve because that's just how the lawyer practices. They always serve, and the client wasn't given the options that you talked about. So they didn't necessarily mean to send something aggressive. They didn't know there was another way to do it.
Yeah. So I do think it starts often with the lawyers. And again, and in some cases, service is appropriate. So I'm not saying all cases you need to give your spouse the heads up or the opportunity to accept service in other ways. But yeah, for the most part, that is probably the better way to start off the process. That's a better tone. Kind of another example is, withdrawing funds from accounts or, making, drastic moves in, within financial accounts, transferring money, things like that right before the divorce process starts, because it sets a tone, throughout that process that just really is contrary to the goal of, being amicable, trying to be efficient.
And it has a feeling of, wait, why are you hiding money? But that isn't really their motivation.
Right.
What do you think? Why do people do that? What's their motivation for moving the money?
I think sometimes lawyers advise them to do it. And I think the second motivation is fear.
Yes, it's kind of a fear-based reaction.
I do.
They think before he or she moves all the money, I'm going to move
absolutely
some of the money. Or maybe they just take half. Well, I just took half.
Yeah.
I'm just trying to protect my half.
Yeah.
But they don't understand that it's not necessary.
Yeah. Right. Absolutely.
It was a very aggressive, it doesn't feel respectful or transparent or that we're working together. But many, many times it's on lawyer advice.
Yeah.
And the lawyer's afraid, well, what if I don't tell my client to do that and all the money disappears?
Yeah. Well, the good news is we do have judges, and we can, file a motion, get in front of a judge, and more often than not, the money's coming back.
I just tell my clients, if all the money disappeared tomorrow, could you live for 1 month off of your friends or family or credit cards until I can get the money back from a judge?
Yeah.
And if they say, oh, yeah, I can do that. Great.
We're good. We're good. Yeah.
Set your fears aside.
Yeah. Yeah.
Okay. Well, those were two really good examples of when people accidentally cause something to be more dramatic. Let's say that they're both agreed. We want to be amicable. We want to be efficient. We don't want to pay the lawyers a fortune, even though we enjoy that. We enjoy
Yes.
receiving your money, but we can make money properly on the next case, right? We don't need to make all the money from one case. So what are some ways by agreement that they could keep their attorney's fees down?
Yeah. So, this is a common question, what ways can I be efficient? And I think that, is so important, because if you take a step back before we kind of get into the specific ways, I think what people don't realize is, a court is going to divide your community estate. Mm-hmm. And the legal fees, for the most part, are going to come out of the community estate. Mm-hmm. So regardless of who's stroking that check, whether the husband is ordered to pay the wife's fees or vice versa, or everybody's paying their own fees, they're all coming out of the same pot.
Right.
And I don't think sometimes clients realize that.
Mm-hmm.
And so what I really try to encourage people, I have that conversation with clients, because I think that is a reality that we see within the divorce process. It is rare that another party would be ordered to pay one spouse's legal fees from their share, because very often cases don't get that far. They settle. Right. And as part of the settlement, you're just dividing what's left.
Well, and as a mediator, I'll tell you, never, never, never does anyone agree to pay for the other person's attorney's fees out of their share. Because their viewpoint is, this was just a cost we had to incur to get divorced. My attorney's fees, your attorney's fees. But it's frustrating to someone if they feel like the other side spent too much or wasted, that they don't approve of the lawyer choice. The lawyer's hourly rate was more than they wanted, so on and so forth. But I completely agree with you. It is coming out of the pot.
Yeah. And, just to say this, there are cases where the legal fees are so what is the right word? Disproportionate. That's the word. Thank you. So they're so disproportionate where, maybe in that final settlement, we do somewhat of a true up or somewhat of an equalization. But for the most part, once the money's gone, it's gone.
Right.
And
Agreed.
So, the ways that, you can minimize the fees, and again, with the goal being, let's try to do this as amicably and efficiently as possible, is hire, joint appraisers, or hire a business evaluator or a neutral professional. We see that in other types of law, such as in collaborative law. We see, that's the whole concept behind collaborative law. Mm-hmm. You have these neutral professionals. Mm-hmm. Well, that doesn't have to be solely within the collaborative process. Mm-hmm. We can do that outside. So, you hire your neutral professionals, and, to help with the valuations, with the appraisals, with, tracing, whatever it is that needs to be done, which saves the estate a lot of money.
Yeah. Instead of you hire your realtor to value the house and I hire my realtor to value the house, why don't we just get together and jointly hire the realtor?
Yeah.
Get one valuation of the house.
Right. Or if someone has gone ahead and engaged someone, I typically, depending on who they've engaged, I typically will say, let that process play out. Let's get their report. We'll get all the documents that it was, based upon, and then we can take a look at it. And if you agree, then great. If you don't agree, then we can have someone else take a look at it, and kind of go from there. So there are other options versus just everyone has their own team, and that's costing, a lot of money, to I guess do the same thing.
Yes. And what's nice about a neutral is they would know, as the professional, they're being hired as a neutral. They represent both parties.
Yes. Yeah.
So they're not going to make any assumptions that only benefit one.
Yeah.
Whereas we know when they represent one client, if there's any assumption, they're going to go
with their client.
Yeah.
Yeah.
Appropriately,
Yeah.
right?
Absolutely. Yeah.
And that's why, one of many reasons their reports may not be the same.
Yeah.
Is they both took extreme assumptions. If they're hard neutral, they're going to try to be fair and pick kind of the middle ground.
Yes. Yes.
So that helps.
Yeah. So that's one way, is to obviously hire, professionals either jointly, neutrally, to kind of streamline the process. The other is, everyone knows about mediation, obviously. So, mediation, but before, because mediation, we've talked about this, can be a very expensive day.
It's an expensive day. If you think about the hourly rate, if it's an 8-hour day,
Yeah.
the hourly rate of both lawyers plus the mediator, it's less expensive than going to trial, but it's still an expensive day.
It really is. And again, if you settle at the end of the day, it's obviously worth it. Mm-hmm. But, if people say, hey, I'm not quite ready to go to mediation, I don't want to incur that cost, another option is just kind of a series of informal settlement conferences. Mm-hmm. So, whether they're exchanged, just via, email, mm-hmm. Or actually getting together, whether in the same room. And again, it's not for every case. I mean, we can talk about that. But when you do have, the right family that can sit in the same room, or maybe even separate rooms without a mediator being present, but going back and forth with the lawyers. So that is an option.
And some of that is a judgment call by the lawyer.
Yeah.
If I have a lawyer on the other side that I could do that with, or if I think the lawyer on the other side is evil.
Yeah, that too.
Then I might need a mediator.
Yeah. And so it just depends on the circumstances. And again, there's, a series of informal settlement, conferences, obviously mediation. And then, we are also seeing some arbitrations, which is using a private judge. And the reason why we kind of look at that as an option is because it can take so long to get into, a courtroom. And the longer a divorce is pending, obviously, the more it's going to cost. Mm-hmm. So if you're ready, to present the case to a judge, maybe one option is to get a private judge and do it in the form of like an arbitration. So
pros and cons of arbitration from your standpoint.
Obviously, the what if. Mm-hmm. I've had that conversation with clients. What if we actually, went before, the judge that, your case is pending versus this private judge? Because, very often they are, retired judges. They just, maybe have a different perspective. And so, I mean, that to me is it's the big what if, in my opinion.
Yeah. And you're kind of comparing what you know about the judge that's sitting to your private judge.
Yeah.
One advantage of arbitration is you do it on your schedule. It's private.
Yes.
You're not in a public forum where anybody could walk in the courtroom.
Yeah.
You control the timing. You're not going to get bumped by another case.
Right.
The judge isn't going to reset you for reasons that have nothing to do with your case because you have an appointment with one person.
Yeah.
They're your only appointment.
Yeah, exactly.
But downside is no right to appeal.
Yeah, I didn't mention that, but yeah, absolutely.
So with district judge, if they do some crazy thing, we can appeal them.
Yeah.
So arbitration, you're waiving that right. Most cases don't go up on appeal.
Yeah. Well, and when a divorce is filed, it's just randomly assigned to one of our 7 courts in Dallas County. And so we're not picking our judge, right? But
if only we could.
Yeah. But we are picking our private judge. And so if it doesn't go well for your client, I could see some pushback. Well, why did we pick this person?
Yes.
So that to me, again, goes back to that.
Consider
that what if, but from a cost perspective, it is something, that should be considered.
Well, last time I was in Fort Worth, they said next trial date, 1 year from now.
I know.
And I just said, what?
Yes.
Excuse me?
Yes.
1 year from now. And especially in family law, people want to get on with their lives. They don't want, if they're ready to try their case, they don't want to wait a year.
Yeah.
So timing could be, that is not the case in Dallas County. We have faster settings than that typically, in Collin County faster settings. I was so shocked.
Yeah.
I was like, excuse me?
Did I hear that right?
What are you talking about?
Well, and people move on. I mean, that's the other thing.
Right.
And, I think just the longer the longer a case is pending, there's more opportunity for things to go wrong.
Oh,
right?
gosh. New boyfriends, girlfriends.
I wasn't going to say that, but since
New
you did,
boyfriends
yes.
and girlfriends at the soccer game with your child, and the other person's freaking out about it.
Yeah. And so obviously, timing. So, the sooner a case can be concluded, obviously the better.
Let's go back to what you talked about, which having either offers sent back and forth or settlement conferences. One thing I like about that is even if it doesn't work and you do go to mediation, now everybody's much more prepared for mediation.
Yeah.
And one thing I see as a mediator is a variety of levels of preparation.
Yeah.
I know you because I've mediated for you before. You're very prepared, always very prepared for mediation. But there are lawyers who are not. Big shock.
Yeah.
And therefore their client is not, and they haven't had some of the conversations with their client.
Yeah.
And we're literally blank white sheet in mediation saying, so who do you want to have get the house?
Yeah. Yeah.
What schedule do you want with your kids? And if they have had none of that conversation, it's very hard for them to mentally understand, accept, and shift a settlement in one day. And so we end up with more than one day of mediation.
Yeah.
So you're kind of doing a pre-mediation run, which then I think heightens your chance of settling on mediation day. And that would ultimately money well spent because it saves them money. They don't have to do, I'm doing 2 and 3. I had 4 days of mediation.
Wow. That's a lot.
Because the conflict was so high but they were very motivated to settle. They didn't want to bring all that emotion or, deregulation.
Yes.
To court.
Yes.
So they were committed to getting it done, but it would help if people had done the type of, let's try to get a little something done.
Yeah.
Now, sometimes it's not a good idea if that settlement talk would result in more conflict.
Yeah.
By judgment of the lawyers. So I could see why sometimes people are like, I don't know.
One of the things that I think that I have started doing, I say started, but it's been over the last several years. And I know, a lot of mediators don't like this because it is a lot to swallow and deal with at mediation. But I do find it being more efficient for the very reasons you're talking about in preparing for whether it's a mediation or, settlement conferences. When a family has children, I mean, obviously there's 2 parts to every divorce. You have your property division and you have your parenting plan, your child-related issues. I go ahead and prepare that full parenting plan that's going to be basically cut and pasted in a divorce decree. And I try to go ahead and prepare that a month or so or as early as possible for my client so that they can visualize, what this is going to look like. Because we talk about conservatorship, we talk about possession and access, support, all of these things. Well, as lawyers, we know what that is.
We're using all that shorthand language.
Right.
They do not know what it means.
And what it will look like, all the little decisions. And so what I try to do is I prepare that parenting plan, send it to my client, we talk about it. And it also helps with managing expectations as well.
Helps you not to get sued, in my opinion.
Well, okay.
Because no one later can say, I didn't know what that term meant.
Right.
That ended up in it said standard possession in the mediated settlement agreement. I have
no idea what that is. And I would not be comfortable having a client sign an MSA where it says standard possession, where they didn't really know or had never seen kind of really what that looks like. I would be very uncomfortable with that. And then taking, that parenting plan, whatever it is that I've worked out with my client, and sending it over to the other side, a week or so before mediation, so that they have the opportunity to go over it with their client and have those same conversations. Yes. So when we show up, whether it's at mediation, a settlement conference, we've all seen this one document and we can work together on narrowing the issues. I find that to be the most efficient way to deal with the kiddo issues. I really do.
I agree with you. I don't know why you said some mediators don't like that, but I can't imagine why.
Well, so I think sending that over like the day of or the day before is, I guess, where
I think it's a lot.
It is
of
a lot.
information. Yeah, it's
And it
very
is
detailed.
yes, and it is a lot for the other side to process all of that.
Yes, yes.
If they haven't seen it and had the opportunity to go over it with their clients. So I think that, but that
plan ahead.
yes. Well, and then, and it's easy because once we have kind of an agreed upon parenting plan, we just attach it to the MSA, and then it's just a cut and paste in the decree. So it really, to me, is much more efficient than just doing a term sheet at mediation and then trying to hammer out all the details in a decree, which, as you know, we end up arguing over.
Sometimes people have to come back to me to do a little interpretation.
Yes.
Of what did our term mean.
Yeah.
But it's a balance, right? Is if no one has seen the 20-page document in advance, it's hard in mediation
to process
it. Yeah. So plan ahead.
Yeah.
Well, one thing you talked about earlier is languaging. And how does languaging help to keep the case a little bit more amicable, a little more efficient?
People come to us, and I always say, it's generally good people going through difficult times.
They're not at their best.
Yes, they're not at their best. And I think, words matter, right? The way I communicate with my client is, I'm very conscious of, because, as we can try to, what would be the right word? Diffuse, communicate down. Not even,
or escalate it.
Yes. And so I do think the way we communicate with our clients and what we say to them, I think, is so important. Our language, not only to them, but to the other side. I find, when someone is very, very aggressive with me, opposing counsel is very, very aggressive with me, to, not necessarily respond on that same level. Because I find, in the end, it just then becomes between the two lawyers. And guess what? The client's paying for it. And we're not moving the needle forward in any positive direction, right?
And it aggravates the clients. We're supposed to copy them on our correspondence.
Yep.
I've had times in my career because I will not engage. I'm like you. I'm not going to be ugly back. So when I get a really aggressive, ugly letter, I just don't respond, or I only respond politely to the part I need to respond to. And I've had clients get mad at me about that. You need to be
more aggressive. Yes.
You're too nice. I'm like, well, I care about getting your goals met, and that is not going to meet your goals.
Yeah.
To have everybody hate everyone. It means you're more likely to have hearings and trials, which are very expensive.
Yeah.
And it's not amicable at the courthouse.
Yeah. But by the way, if that's what you want, we can do that. And I will do that. But it's not, in the end, it's not helpful. I mean, right. It's really not. I often see when I get those aggressive emails or those aggressive letters, I feel like more often than not, they're being written by the other attorney just to forward to their client to show, oh, look, we're being really aggressive.
I'm a bulldog.
Yeah. And I'm like, okay. I mean,
there's no audience.
I know, except their client, right?
Right.
And so, again, if that's what the client wants, then sure. But I just don't see how, that's benefiting, their goals or their family, and certainly if they have children, their children in any way.
Do you suggest any type of resource for your client, like the BIF book or individual counseling or something to help them with their own communication?
Yeah, I mean, so, when there's children, that's kind of easy, right? Because we have our parenting facilitators and we have our parenting coordinators, and, or they can do some co-parenting, counseling and things like that if it's, to kind of help with the communications on the children. Also, the online tools that, we see more and more of, where parties can communicate through these online tools. I think one example I think is the most common that we see is like our family wizard,
I
right?
love our family wizard.
Yeah.
Yes.
And so, but there's others now that are just as good or maybe even better, but, you know, that allows for better communication between the parties. So when there's children, I think, you know, there are lots of options out there. You know, when there's not children and we're just trying to get through the divorce and deal with the property division, it does become a little bit more challenging because you are working more and more through the lawyers.
Mm-hmm.
And so when I do see whether, an inability to communicate for whatever reason, maybe my client's the more aggressor, the aggressive of the two, or, on the other end being, more, or less aggressive, for the lack of a better word, encourage them to get a counselor, to work with someone, because those issues have existed for a long time, that dynamic.
Yeah.
And so I think, and will continue to exist. And so I think when there's kind of this, imbalance, between the parties and a breakdown of communication, I do try to encourage counseling.
I think everybody going through a divorce should be in counseling.
Yeah.
It's a major life change.
Yes.
And it just gives them an avenue to talk about it.
Yeah.
They're talking with us about it, and we're kind of counselors at law, but
Yeah.
we're not actually
Yeah.
trained psychologists.
Right. Yeah.
So it gives them somebody to talk through the emotional aspect, but it's also a good coach to say, when she or he does this, do I even need to respond?
Yeah. Yeah.
When you and I started practicing law, there was not texting like there is today.
Right.
And now it's shocking the level of communication that is in print on the text.
Yes.
And can become an exhibit.
Yeah. So clients will say, in fact, I had one yesterday, should I just, block him? I'm like, no, try to ignore him, because these texts are coming through and they're just crazy.
Yeah.
And
not every communication requires a response.
Yeah. Yeah. And that is a very good point. I really try to encourage people, silence or a lack of response is as powerful or more powerful than responding.
Mm-hmm.
I mean, it really can be.
And sometimes the whole reason that they're sending the text is to get a response because they want to keep engaged.
Yes. Yeah.
So if the person can understand that, and maybe through their counseling understand, hey, by responding every time, I'm worsening it. Yeah. Whereas at some point they'll just stop.
Yeah.
If they don't get the
reaction.
Yes.
Yeah.
They want the reaction.
And we have such great resources, of counselors and therapists and programs here in the Dallas area. I mean, yeah. And
are you familiar with The Biff Book by Bill Eddy?
Yes.
I love the Biff Book. Because once I give it to my client, then I can say, that doesn't sound very Biff of you.
That's funny.
And they're like, I know. I'm like, did you read the book that I gave you? Did you read the book? They're like, I read it.
That's funny. That's funny.
I have had clients where for a time I said, send me the correspondence before you send it to them, and let me edit it for you just long enough for you to get the feel for it.
Yeah.
It's more of a professional communication now because you're not in relationship anymore.
Yeah.
You are, in the sense, if you have children together, you're going to be co-parents, but you don't need to care about a lot of this crap you've been fighting about forever.
Yeah.
That's the joy of divorce.
Yes. Yes.
You don't have to keep having these same fights.
Exactly. We just need to get through this process.
Right.
Yeah.
And if you realize that your most important audience is the other person, because most likely your case is going to result in settlement.
Yeah.
It might affect how you treat them.
Yeah. Yeah. And, just going back to just the whole process and working through it, one of the things that I think is so key that we really haven't touched on, but I want to bring this up, is transparency.
Yes.
I mean, when we don't have transparency in a divorce, that's where a lot of the issues come up.
Oh,
I mean,
people are very worried about that too. One of the top worries is they're hiding something.
Yes. And so I think, and even, I have clients who are like, God, I just don't want to hand that over. I mean, and I'm like, is it really going to matter? I mean, at the end of the day, I mean, we can execute confidentiality agreements, I mean, which is very common, where everything is, contained within the divorce. No one's going to go out and show stuff. I mean, that is particularly common when we have, business interests and those things. But, I really do encourage as much transparency as possible, because if you don't produce whatever it is, that becomes what the other side is focused on, right? And so it's like, let's just turn it over,
And if we don't identify all the property, we know under the law, it can be divided post-divorce.
Right.
That's my best selling point on that.
Yeah.
Like, hey, you have to list everything.
Yeah.
Or she or he might get it later. Then they're like, oh, I better list that.
And if you don't turn it over, I mean, they're going to, a court's going to order you to turn it over.
Right. Why pay for that fight?
Yeah.
Why pay for the privilege for the judge to be mad at you?
Right. Exactly. And we know our judges just love those types of hearings.
Discovery fights are the worst.
Yeah.
Oh,
we all hate them.
Well, I really appreciate you being here today. So for our audience, where do you practice? What areas do you cover? Dallas, I know. What else?
Yeah. So my office is here in Dallas, and I have cases really, all over the Metroplex, Tarrant, Collin County, Ellis today. Yes. Sometimes we'll go out to Kaufman, and then obviously Denton as well. So, around the Metroplex, every once in a while, I'll have cases, a little bit further east or south, but, I've had a couple of cases in Austin more recently, Bexar County as well. So, really all over. I'm licensed in the state of Texas, so all over.
Well, I would highly recommend if anybody needs a lawyer, Liz Porter.
Well, thank you.
With a great firm too, and has the resources to handle large matters. And you do divorces, modifications. Do you do prenups and postnups?
I do.
Prenups, postnups, and sapsers, meaning they were never married, but they had children together.
Yes, correct.
Anything else that I didn't list?
Yeah, I mean, I do collaborative law.
That's great.
We talked about that a little bit. Just really anything family law related. We don't do estate and trust. So just to clarify that, but yeah, divorce, enforcements, grandparent rights, terminations, anything that's related to our family code.
Excellent.
Yeah.
Thanks so much for being here.
Thank you, Melinda. Enjoyed it.
Thank you so much for watching. Please tune in again to the Melinda Eitzen Show.